Hello and welcome to the latest in my series of short podcasts in which I'll be giving tax and other practical advice for families. My name's Claire Charlton and I am Head of Personal Tax at Rycroft Glenton. And in the course of my work I have learned various practical tips which I am passing on by way of these podcasts. Just simple things that can help families deal with financial matters. This podcast is entitled Looking After Your Perennials, and the title came about because I was speaking with one of my clients, a very sprightly 85-year-old lady who objected to being referred to as elderly by her family and other institutions. So we had a little debate about what she thought people of her generation should be called, and she came up with a very clever name. She said she would like her generation to be known as the perennials. Her words were, "We're a bit shabby in the winter, but we come back every spring." So my first piece of advice for families and perennials in particular is to make sure that your will is up to date. Ideally, I think wills should be reviewed every 5 years, and certainly they should be reviewed after a major event in the family, such as a death or a birth of new grandchildren, a marriage, or the sale of a significant property. I also recommend that you introduce all of your advisors so that they can work together. So I'm talking here about your tax advisor, such as myself, your solicitor and your financial advisor if you have one. Because it's my experience that as people get older and are less interested in their affairs, it's a really good thing if the advisors are already working together and can continue to do so on behalf of a client as they get older. It also means that you get very balanced all-round advice, because we each have a slightly different approach and a different view, and can look at balancing income needs against tax efficiency, against inheritance tax and care fee planning and that sort of thing. And if something changes or something happens, we can speak to each other and just check that what one of us is planning to do won't affect or undo something that's been done elsewhere. My next tip is to think about simplifying your affairs as you get older, because there are certain things which can make the job of administering your estate much, much easier. I'm talking here about things like very small shareholdings that you might have acquired by virtue of some sort of windfall. For example, if you've owned a policy through an insurance company which has floated on the stock exchange, you may well have acquired a small number of shares in that company. And subject to looking at the capital gains tax implications, it may be worth considering just getting rid of some small shareholdings like that, particularly foreign ones, because they really can cause a headache for executors. I also recommend making sure you have at least one joint bank account with another person, be that your spouse or another member of your family. It's something that we can advise about, particularly if it's not a spouse, just to make sure there aren't any inheritance tax implications. But a smallish joint account is a good idea, because on death, your assets are frozen and nobody can access your bank accounts until probate is obtained, which can make things difficult in terms of paying for funeral expenses, etc. Whereas a joint account remains open with the surviving account holder able to operate that account. That brings me on to the subject of powers of attorney. A power of attorney is a legal document that allows someone to make decisions for you or act on your behalf if you're no longer able to do so, or if you no longer want to make your own decisions. And I think there are some important things to understand about powers of attorney, because they're very, very useful documents. The first thing is they're not just for perennials. I think everybody should have one because they can be used in the short term as well as in the long term. So I have one. and my attorneys would be able to act for me for a temporary period if I was in hospital or away on an extended holiday. The other point that's not always appreciated is that if you're married or in a civil partnership, you may have assumed that your spouse would automatically be able to deal with your bank accounts, etc., and make decisions about your care if you lost the ability to do so. But that's not the case. Without a lasting power of attorney, they wouldn't have the authority to do those things. And the final thing I'll say about powers of attorney is it's no use waiting until you need it before you do anything about it, because then it's too late. So the thing is to set one up when you are fit and well, and then it can just be used when the need arises. It doesn't have to be operated straight away. And so while you continue to feel able to deal with your own decisions and affairs, then that's fine. But as soon as you're unable to do so or do not wish to deal with your own affairs, then the power of attorney can come into effect. And lastly, attendance allowance. This is a state benefit which is available for people who need extra help, either in a nursing home or in their own home. It's a valuable benefit because it's just under £90 a week, and then I think there's an extra allowance for people who need help at night. And I think the interesting thing about it is you don't necessarily have to have a requirement for specialist nursing care in order to qualify. You may just need help with cleaning and gardening and that sort of thing. The form is a bit daunting, but I believe there is help available from charities like Age UK who can assist with completing the form. But it's certainly worth looking into if there is anyone in your family who you think may qualify. So that's the end of this podcast. Thank you very much for listening. And if you would like to discuss any of the matters I've raised, please do get in touch. My contact details are on the front page of the podcast. And I do hope you'll join me for future podcasts in this series.